Good morning, Honorable Vice Minister of Foreign Affairs, dear speakers and guests. On this day, 2 years ago, European Court of Human Rights issued a decision in the case of Drėlingas against Lithuania. The court ruled that the conviction of who participated in arresting and eventually killing Lithuanian partisans, as for part, has not violated the European Convention of Human Rights. It was a huge moral victory for all those who suffered brutalities of the communist regime in the Soviet-occupied countries. On this day, 2 years ago, I was also starting my internship, Fulbright internship at Columbia University in New York. And on that day, I was already wondering if somebody somewhere already started organizing this conference, the conference devoted to this interesting case. So it appears that we are here now together to organize and be in this conference together. So without further delay, I give for the first keynote speaker, Vice Minister of Foreign Affairs of Lithuania, Mantas Adomėnas.
Occupying power as genocide and recognize partisans as representatives of the Lithuanian nation. It's a landmark decision that has reverberations far beyond the strictly legal context. It's vindicated the historical truth. I don't know where these noises are coming from, but they're not coming from me. So it vindicated the historical truth that motivated and inspired Lithuanians' fight for freedom for many decades. Regardless of the fact that it's very difficult for researchers nowadays to analyze the crimes committed by the Soviet regime, as access to the Russian archives is hardly possible, and the situation in the Russian Federation does not make any research into Soviet crimes any easier. Therefore, it's very important to ensure that the memory of the Soviet crimes and repressions committed in the future, as well as other European countries after the war, is preserved and passed down to the new generations of researchers. A couple of decades ago, we used to talk a lot about Nuremberg, and what a pity it is that there was no Nuremberg trial for the Soviet regime, that in fact a totalitarian regime which was at the time committing crimes against humanity sat in judgment over other totalitarian regime of the time. But what we see now in the Drėlingas case is a sort of Nuremberg, a sort of second Nuremberg coming piecemeal, bit by bit, and trying to vindicate and perform this historical function that did not take place when it was due. As we all know, the resistance to the Soviet occupation in Lithuania lasted for more than 10 years. Its key aim was the restoration of the independent Republic of Lithuania. Around 50,000 active members and 100,000 supporters of armed resistance participated in this fight for independence. During the most brutal period of Soviet occupation, more than 20,000 freedom fighters and their supporters were killed, and 120,000 Lithuanians were deported to Siberia and the areas in the far east of Russia. Such loss is more than painful for a country of not fully than 3 million. This war of Lithuanian citizens against the superior adversary marks an exceptional determination and devotion for the higher human values and ideals. In the Žilinskas case, the European Court agreed with the assessment of the Lithuanian National Court that partisans should be recognized as a significant part of the Lithuanian nation. Therefore, their murder and extermination should be considered as partial genocide of the Lithuanian nation. It was a big legal victory 2 years ago, and it's also very relevant today when we witness severe violations of fundamental freedoms, as well as threats to democracy and even attempts to rewrite history. Lithuania continues to draw attention of the international community to the recent actions by the Russian Federation, which, as legal successor of the Soviet Union, raises deepest concerns about in its defying of international law and international human rights norms. Fairly recently, Russia has covertly initiated proceedings against Lithuanian judges, prosecutors and investigators of the January 13th case that was launched to investigate the Soviet aggression against civilians in Vilnius in January 1991. Then the Soviet military troops brutally murdered 14 and injured several hundred peaceful demonstrators. Former Soviet officials were found guilty and sentenced for war crimes and crimes against humanity for their involvement in the Soviet aggression against the independent Lithuanian state, to raise them for future generations in order not to allow that such crimes may be committed and justified again. I wish you all to have very interesting and fruitful discussions in the upcoming conference. Thank you very much for your attention, and I once again sort of apologize for having to leave this very interesting discussion, which is beginning. I already saw the program. It promises to be very, very interesting. I'm certain I can read it up later on when it's published. To a very good and productive day. Thank you.
Let me introduce our next speaker, Professor William Schabas. He is currently acting professor at Middlesex University in United Kingdom. But unfortunately, because of his trip to Canada, he couldn't attend our event online. So we will have a record of his speech, about 9 minutes. And his speech will be how the European Court of Human Rights reversed the Vasiliauskas judgment, meaning that there will be some clues what happened between and Drėlingas case. So, dear professor, the floor is yours.
Good morning. I come to you from Toronto, Canada, where it is the middle of the night. And I hope you'll understand, therefore, why I have recorded this talk rather than delivered it in person. I wish I could be there with you live and participate more actively in the conference, but it's not possible. My involvement in these cases or in this issue dates back to not quite a decade ago when I was counsel to Lithuania in the Vasiliauskas case before the Grand Chamber of the European Court of Human Rights. And as decisions go, some of you are lawyers and you'll understand this, to lose a judgment by a vote of 9-8 is a rather painful experience, particularly because the judges of the European Court of Human Rights in the Grand Chamber are to some extent decided by lot. In other words, it's a bit of a lottery, and depending on the name that gets pulled out of the hat, the vote could be 9-8, as it was in Vasiliauskas in favor of the applicant, or 8-9 in favor of the state. The decision in Vasiliauskas, of course, like the decision in Drėlingas, is about Article 7 of the European Convention on Human Rights. Article 7 of the European Convention on Human Rights is a fair trial provision. It is part of the convention dealing with fairness in criminal proceedings, and it specifies that individuals are not to be tried and prosecuted and sentenced for crimes that were not recognized as criminal offenses at the time they were committed. In my view, much of the debate about Article 7 can be rather too technical, because given that the issue is fairness in an Article 7 case, the main question we have to ask is whether the accused was properly warned that they could be prosecuted for a serious crime when the act took place. And if that's not the situation, if it's a new crime, if it's a decision that was taken to introduce something that was never criminal and was never punishable before, then it's clearly a violation of Article 7. It's not so clear, it seems to me, when the focus is on labeling. And I think that to some extent, is the problem both with Vasiliauskas, although one that is resolved in a way in the Drėlingas case. To me, there's no doubt that Vasiliauskas was fairly warned by the 1950s when the acts for which he was charged and convicted took place, that these could be considered criminal under the law of nations, that they could be considered criminal either as crimes against humanity or as acts of genocide. A big part of the argument that was submitted to the Grand Chamber back in the Vasiliauskas case was that the resolution on the crime of genocide adopted by the General Assembly of the United Nations in December of 1946 defined genocide as including political groups. Now, the convention that followed the definition of genocide and the resolution on genocide of the General Assembly in 1946 did not include political groups. There was a decision that was taken. That's a detailed discussion, and in the few minutes that I have today, I'm not going to go into an attempt to even unpick that question. But it was decided by the General Assembly when the convention was adopted that political groups would not be covered by the protection accorded to groups under the Genocide Convention. But that didn't negate the resolution in adopted 2 years earlier, Resolution 96 of the General Assembly, particularly because the resolution that was adopted in 1946 wasn't meant to be a law-making resolution. It was the convention that made the law in 1948. The resolution in 1946 was declaratory of the state of law, and it was meant precisely to address those who claimed that retroactively prosecution for the crime wasn't governed by international law. And Resolution 96 made it clear that people could be prosecuted for the crime of genocide committed against not only national, ethnic, racial, and religious groups, but also political groups. So I think that Vasiliauskas was fairly warned, but as I say, 9 judges of the 17 in the Grand Chamber didn't seem to agree, and that's unfortunate because although as a lawyer for one side in a case, people will always look at you and say, well, you're taking that side because you were arguing for the client for that position. But I want to say that I'm firmly convinced, as well as a legal scholar who studies these matters, that the position that Vasiliauskas was fairly warned that he could be prosecuted is the better one. Well, the decision of the Grand Chamber was unsatisfactory, and that it wasn't surprising that another case would come before the European Court of Human Rights, and that's Drėlingas. Drėlingas, unfortunately, doesn't really resolve these difficulties at all, because what Drėlingas does is approach Vasiliauskas as a problem of the way the issue was packaged by the courts of Lithuania. And because of the way the issue was presented, particularly at the level of the highest courts in Lithuania, the Drėlingas decision says, well, it wasn't properly packaged in Vasiliauskas, and now it's been changed, and now it's properly packaged. And the difference, of course, was identifying the targeted group, not as being a political group, but rather as people who were, we might say, politically involved, politically engaged on behalf of a national or ethnic group. And that satisfied the chamber, the 7-judge chamber in the Drėlingas case. The case ought to have come back to the Grand Chamber to be revised. The dissenting judge, Judge Motok, said that. She said that the chamber should have submitted it immediately. The chamber has the possibility of doing this when it feels that it's going to overturn a precedent or contest a precedent by the Grand Chamber. It has the option of referring it immediately and not taking a decision. But it chose not to do that. And I think that was because the strategy, if you want, of the other 6 judges of the chamber was that they were simply addressing how the case came to the court and sending a signal to Lithuania that in the future, if you package the issue this way in proceedings, you need not fear a challenge under Article 7 of the European Convention on Human Rights. So what we have is a kind of sui generis decision. Will it be a precedent for anything? I really have my doubts. I'm not aware of the extent to which it's been used in proceedings within Lithuania. It may be decisive in a few cases, although one expects that with the passage of time, these cases are going to be less and less likely to be prosecuted simply because the people who might be subject to prosecution are no longer with us. taking a kind of a broader view of it, it's also interesting to see it as a chapter in the efforts by the European Court of Human Rights to deal with dark aspects of European history. And we have a mixed package already from the European Court of Human Rights. Another case that I was involved in, Yanovich et al. Versus Russia, was a case dealing with the attempts to get the European Court of Human Rights to engage with the Katyn massacre, and there the majority declined to do that. But we will continue to see cases, I think, coming before the court, particularly when we address matters about the historical narrative associated with with prosecutions and with justice, including those dealing with crimes that were perpetrated in Lithuania and elsewhere during the Second World War and at the time of the Second World War. And the court may have to return to this again and again. It's a subject for a much bigger seminar that deals with how the European Court of Human Rights addresses these aspects of the distant past in Europe. Thank you.
Thank you so much. And I was informed that due to the technical issues, we will need to make a 15 minutes break and to take a coffee again. So just take your time to take coffee again. And I am sure we will be back in 15 minutes. And the audience online also, if someone is watching out there. So we will be back in 15 minutes.
So it's a great pleasure and honor for me to preside over this first panel, which is titled Universal Legal Formula in Drėlingas case, where we are going to discuss very interesting and important, mainly legal issues regarding that were raised in Drėlingas case and beyond. And I would like to welcome dear speakers. So here we have on the panel Andres Parmas, who is Prosecutor General of Estonia and from University of Tartu as well. Dr. Lars Berster, who is acting professor and the chair of Artificial Intelligence and Criminal Law at University of Passau, Germany. And Gustavo Minervini, who is a PhD candidate from University of Naples, Italy. So it's very nice to have such friends from different parts of Europe. And without any ado, I would like to ask Andres Parmas to present his thoughts about the role of national definitions of crime of genocide in developing the definitions of the crime of genocide in international law. And I also would like to notice that Andres Parmas is only Prosecutor General of the Estonia, but he's also had a diverse international career, both nationally and internationally. He worked at the Supreme Court of Estonia. He was a judge at the Tallinn Circuit Court. He was in the roster of judges of Kosovo Specialist Chambers in The Hague. And as well, he's currently appointed to the board of directors of the Trust Fund for Victims at the International Criminal Court. So his experience is really impressive, and we are looking very much forward to hear your thoughts on this matter.
Thank you for the introduction and then for the kind words. It's nice to be here, nice to have this opportunity to speak on this occasion. And what I have to say about the matter is that the Baltic states, they have been struggling to investigate and to prosecute international crimes committed during Soviet occupation, as well as acquainting the rest of the world that the idea that such crimes were indeed international crimes, war crimes, crimes against humanity, and even genocide. It has been a bumpy road. And as can be witnessed also by the Lithuanian cases such as Vasiliauskas or the Drėlingas case. In my very short intervention, please allow me just to comment on the definition of the crime of genocide from that perspective. As generally known, the universally recognized definition of genocide embraces 4 protected groups: ethnic, national, religious, and racial groups. Any other common denominators of persons have consciously, or I would even say maliciously, exempted from the circle of protected groups. Different negotiating states of the Genocide Convention had different reasons to limit the scope to only these 4 groups. And one could say that for the exemption of political groups from the list, we can mainly send our thanks to the Soviet Union, which of course at the time of negotiations was namely persecuting and destroying any kind of political dissent in its empire. Since the adoption of the Genocide Convention, there has been a move to try to widen the circle of protected groups, also specifically to include political groups into its scope. Think, for example, on the UN Special Rapporteur Whitaker's report already in 1985. However, so far it has been with no avail. So what to do? The criminal codes of many countries entail their domestic entail in their domestic definitions of the crime of genocide more groups than these 4 universally recognized groups. Quite prominently so also political groups. In a world where there is a lack of common ground to verbatimly agree on widening of the scope of the definition of the crime of genocide, these domestic statutes and also respective domestic case law becomes of specific importance. If the number, or should I say when the number of states grows whose domestic criminal codes include a wider form of the crime of genocide, it will also help to boost up respective case law, to grow awareness of the problem, and eventually bring to a situation where there will be more ground to widen the definition also on international level. So therefore also cases like Drėlingas add their little but very important stone in this pyramid. And I think that this is the reason why we're here today, and this is the importance of this case. This is one of the most prominent cases where, as Professor Žilinskas has said, although through a back door, the idea or the concept of political groups actually also belonging to the groups that are worth protection through the definition of the crime of genocide is there. Thank you.
Okay, so I'm very thankful for Andreas for his first initial thoughts. I think we will have more then to put into discussion. And now I would like to ask for Dr. Lars Beste intervention, who is, as I said, an acting professor of international criminal law, German criminal law and legal philosophy at the University of Passau and the University of Cologne, Germany. And again, Lars has an impressive career because he was also a judge, so he was the one who was not only researching the law but applying the law. And I think this practical approach is also very important and makes a real difference. And also he's written numerous publications on questions of international criminal law and co-authored a treatise on UN Convention on the Prevention and Punishment of the Crime of Genocide. As well, he's a member of scientific committee of Yahat in Unum, a Paris-based NGO who investigates in the Shoah and the Porajmos in Eastern Europe. So, having in mind your interest in Eastern Europe, I guess Drėlingas case was of particular importance and interest to you. So, dear Lars, please, the floor is yours. I hope microphone is working.
So
we're looking for your intervention.
Okay, thank you very much. Dear Dovilė, esteemed colleagues, the crime of genocide notoriously requires an element, a special element, an element of special intent on the part of the perpetrators, namely the intent to destroy a protected group in whole or in part. Now, according to the prevailing restrictive understanding, the notion destroy only denotes the physical or biological annihilation of the respective group, but does not extend to forms of social destruction, that is, the dissolving of the group as a social entity by eliminating the cultural ligatures or links or bonds between the group members. In the cases of Vasiliauskas and Drėlingas, the courts readily jumped to this restrictive understanding and quickly narrowed their view to the allegedly intended physical destruction of the Lithuanian partisans, including supporters and families. This then carried troublesome questions in its wake. Did the partisans enjoy protection under the Genocide Convention as a standalone political group? And if not, did they at least qualify as a sufficient part of a much larger ethnic or national group of Lithuanians? In my humble view, the courts missed a chance here. They could and should have given deeper consideration to the increasingly controversial question whether the cultural destruction as well, and in case of affirmation, if the ethnic national group of Lithuanians as a whole was targeted by genocidal intent. Arguably, extending intent to destroy to certain forms, at least, of social or cultural destruction would be much more in line with wording, the spirit, and the objectives of the Genocide Convention, and I shall only give two arguments here. Firstly, when the convention was forged, the chief objective of criminalizing genocide was to protect the right to exist of such human groups as may be regarded as the spiritual resources of mankind, as Raphael Lemkin put it, and then whose disappearing would hence result in great losses to humanity in forms of cultural or other contributions, as the United Nations General Assembly said. Quite clearly, the Genocide Convention's fundamental concern to uphold the cultural and spiritual multiplicity of mankind is no less imperiled by the social dissolution of a group than by the physical dissolution or killing of the group members. The effet utile principle of treaty interpretation hence strongly militates in favor of an extensive notion of the term destruction. Secondly, reducing destruction to forms of physical annihilation fails to explain why genocide can be committed by acts that leave the physical integrity of the group members unharmed, such as causing serious mental harm to members of the group or transferring children from one group to another. It only remains to assume, therefore, that the inclusion of such acts sought to cover detrimental effects on a group's social texture and peculiarities as well. These considerations, among others, would have opened up an avenue to argue that the specific intent requirement already at the time of the occupation of Lithuania did extend to forms of social or cultural destruction. Extending genocidal intent to social destruction is not to say, however, that the subjugation and Sovietization policy carried out in Lithuania would automatically turn genocidal in character, as, at least from the present viewpoint, only the intention of particularly grave infringements upon the social texture of the targeted group should qualify as genocidal. So, whether at all there is such a thing as social genocide under international law, and if so, whether Soviet policies in Lithuania qualified as such, remains open to debate, and entering into this debate amidst the present panel of learned scholars and practitioners of international law is a great privilege. Thank you very much.
Thank you very much, Lars. Indeed, you raised very important questions again. I think we will have a fruitful discussion. And now I would like to pass the word to our third participant, Gustavo Minervini, who is a PhD candidate and teaching assistant in international law at the University of Naples Federico II. We are actually very good friends with this university, and we do enjoy our scientific collaboration with them. And Gustavo has already published in different prestigious journals of international law, and he also was one of the first person from non-Lithuania who published on Drėlingas case. And that's how our contact immediately was established. So, and just recently he did an internship at the International Criminal Court, so I guess he will come with a fresh views and perspective towards this case. Please. Gustavo.
Good morning. Yeah, I guess it works. Good morning, everyone. First of all, thank you very much for your introduction, Professor Žilinskas, and obviously thank you, Dovilė, for having organized this conference, and I mean even more for having invited me. So, moving directly to the substance of my presentation, because I saw that time is already running, as you might have seen from the title of my presentation, I will deal with the compatibility of the interpretation of the crime of genocide provided by both Lithuanian domestic courts and the European Court of Human Rights with the principle of legality, so the nullum crimen sine lege principle enshrined in Article 7 of the European Convention on Human Rights. Well, in this respect, as a legal scholar, I will provide a purely legal assessment of the judgment rather than an historical, I would say, account of the infamous Soviet crimes. So in my personal view, the judgment of the court clashes with the principle of legality, and hoping to be able to adhere to the strict time slot allocated, I will try to briefly explain the reasons why. First, the very interpretation according to which Lithuanian partisans were found to be a part of the Lithuanian national and ethnic protected group is a bit problematic. In order to understand this conclusion, I would recall that Article 2 of the Genocide Convention requires the perpetrator to act, and I read, with an intent to destroy in whole or in part a national, ethnic, racial or religious group as such. Well, let's briefly focus and let's remember this wording as such. Indeed, this wording has been, I would say, often overlooked, but it's quite relevant for the case at hand. Indeed, the wording as such expressed the very idea of targeting the group through attacking its members. So the requirement, this wording has been generally interpreted as requiring that the perpetrators specifically choose their individual victims because of their allegiance, their membership to the protected group targeted by the genocidal campaign. The implication of this interpretation is relevant because we could imagine a killed campaign which is aimed at the destruction of so many members of a protected group that the threshold of the wording in part is passed. However, I would say that it is necessary a second assessment, and the second assessment concerns proving the fact that victims were specifically chosen because of their allegiance, because of their membership to the protected group. In other words, the wording as such has been interpreted as requiring, as conveying the idea that the group and the victims are targeted because of their ethnicity, their nationality, their religion, or their race. Well, by reading the judgment of the court, the European Court, this point is, at least for me, not clearly made. My understanding of the judgment is that the court firstly defined a national ethnic group, which is Lithuanian population, and then a political subgroup, that is to say Lithuanian partisans. I mean, I'm not claiming at all that Lithuanian partisans were not fundamental, and in this respect, I understand and I agree with the reasoning of Lithuanian courts, according to which partisans were fundamental because they fought to protect Lithuanian nationhood and identity. However, I'm afraid that from a purely legal point of view, this might not be enough. Indeed, one should ascertain, the court should have ascertained that Lithuanian partisans were specifically targeted because of their nationality or ethnicity, rather than because they were struggling, they were fighting against the occupying power. So this is the first critical point I found in the judgment. And the second one, I will try to be really brief, is that even if we consider, if we come to the conclusion that Lithuanian partisans did actually constitute a part of the Lithuanian ethnic and national group, so accepting the so-called ethno-political genocide, for me there would still be an issue concerning the meaning of the wording "in part," as enshrined in Article 2 of the Genocide Convention. This wording has been interpreted in various ways: quantitative approach, so a high number of people being targeted; a qualitative approach, so the leadership of the group; or also a geographical approach. Well, the problem in my view is that the court, the Lithuanian courts and the European Court of Human Rights adopted a qualitative approach. So partisans were a significant part because they protect the nationality, the identity of Lithuanian national and ethnic group. But this interpretation, I hardly see it as foreseeable in 1956 when the crimes were committed. The first reference I was able to find, and I mean also Professor Schabas identified this as the first reference, is in the already recalled Whitaker report. So we are already in the 80s. So my point is that there is an issue with the foreseeability of this interpretation. And in this sense, the very Grand Chamber of the European Court of Human Rights concluded in the Vasiliauskas case that the qualitative interpretation was not foreseeable. So this briefly, I hope I respected my time slot, concludes my speech. Thank you.
Okay, thank you very much, Gustavo. So now I would like to open floor for the discussion, because we indeed have many issues from the national regulation to cultural genocide to critique of European Court of Human Rights decision. So, before asking for interventions from the room, I would like to put the first question myself, if nobody's against. So my question is, we let's say in general view, consider that Drėlingas case is kind of moving forward with the concept of genocide that started, I should say, sometimes in ECTI jurisprudence of former Yugoslavia, and perhaps we should mention a case of Srebrenica, where for the first time destruction of rather not so big in numbers group, I'm speaking about this terrible killing of Muslim boys and men, was recognized as a genocide. So before that, genocide was understood that this should be a really massive thing, right? Like Rwanda, like Holocaust, like some other killings. So do you see any threats in this approach that now in Drėlingas case happened? I mean by the fact that somehow we are diminishing the meaning of the genocide by introducing smaller groups into its ambit. Because as far as I know, in Russia-controlled South Ossetia, if I'm not mistaken, there is also a museum of genocide regarding Russia-Georgia war in 2008, where they kind of recognized as genocide killing when the number of victims was around 100 persons, and okay, the consequences are not consequences, circumstances are really murky there. But the general trend, do you think that this might be a new avenue for international criminal law? And on the other hand, is this avenue perspective? How do you think? So please, anyone who would like to take the floor, or we can just yeah, please.
Okay, let's see if I can address that question properly. Frankly, of course, it may be viewed as a new trend in international criminal law to give more recognition to the quality of certain portions or fractions of a group in terms of whether that fraction depicted a part that qualifies under the definition of genocide. But I think that even in the incipient stages of the forging of the definition of genocide, maybe it was not expressed properly just because the Holocaust was just such a towering event, and everybody thought of such huge numbers being exterminated of people. But the underlying rationale of genocide already allowed, even in the incipient pages, for quality, for aspects of quality to be counted in, because as I try to mention quite briefly, if I already mentioned, the chief perspective of the Genocide Convention was to prevent human groups that are contributing culturally to mankind, to prevent such group from being brought to extinction. And this was the main objective. And so if it hadn't been the Holocaust, but maybe a different scenario, let's say somebody would have embarked at the time to annihilate the Catholic Church by just killing all the priests, which may be a tiny fraction of all members of that church, but a very vital part of the church. Maybe one every 1,000 member of the Catholic Church is a priest. But if really all priests would have been killed, that would have been a crippling blow to the Catholic Church, absolutely. And that church could have been destroyed by such a move, even though only a tiny portion would have been attacked. So I'm quite sure that if that scenario had happened at the time, those who forged the Genocide Convention would have agreed that this also would have been some type of genocide they meant to address. So it is a new development, but already in the incipient pages of the forging of the definition, recognizing qualitative elements maybe is already part of the picture.
Okay, thank you very much. Andreas, would you like to react?
You come out with questions that are good enough to have a seminar of its own for 2 days or so. But I think that the size of the group such does not matter, because the groups that can be put under these 4 headings can be smaller, can be bigger. In Brazil, in Amazon, there are living tribes, you can say ethnic groups that are pretty small, maybe just some hundreds of people. But if in order to try to cultivate the land there, you extinguish such groups, isn't that genocide? It's absolutely it is. And this qualitative approach, of course, to not to target in a quantitative manner very many people, but a representative portion of that. That's the main idea, I think, behind the in part. Otherwise it actually would not make much sense. This example of Catholic priests as a representative group of the Catholic Christian faith is very good. It can also be the when there is a ethnic group, let's say, where there are little number of literate people who are carrying on the cultural tradition, or where we are speaking about hierarchical society where only some elites are those who are actually carrying on the traditions or the culture, then extinguishing this part of the group inevitably brings to an end of the group. And I should say that there is, so one more thing about the definition of the crime of genocide. There is complete lack of logic in this definition. So we are talking about these 4 groups. Why these groups? There has been different explanations that these are stable groups. In what sense is a political group less stable or less a faith than a religion? Or, of course, when we think about Afghanistan today, it's not so easy to change your religion, but in some other parts of the world, I'm a Catholic Christian today, I'm a Muslim tomorrow. What's the problem? To change the nationality in Europe, what's the problem? It takes a couple of years to change the passport, and that's it. I'm a citizen of a different country. And as you pointed out with the issue of physical destruction, again, that should be kind of the underlying idea, but then we come to the mental or physical suffering and separation of children from the group. So how come that separating children from the group, bringing to end of the group, let's say in 20, 40 years, because they cannot have children within the group anymore. This is genocide, but separating men and women is not. This doesn't make any sense at all. So this is a purely political definition anyway. We have to live with this because this is how the international law works. And we have to kind of find our ways out of this bush. I'd say that the Srebrenica case is one good example of that, because there, if the approach on the genocide would have been wholesome from the onset, also including the concept of so-spoken cultural genocide, not an issue. The main idea was just to wipe out from the Srebrenica area the Muslim population by whatever means. Killing all the men was just good enough as compared to deport them or just to ship them off from the region. Go and live somewhere else, not here, we don't like you. But it was exempted from the definition. Now you again had to circumvent and to take not a part of the group, but a part of a group, as such.
And Gustav, again, in general, I would like to know your view. How do you think that, okay, we can look back at the Drėlingas times and you can find problems, but what about if we're looking forward? How do you think this now, let's say, interpretation presented by the Drėlingas, how do you think, looking forward, does it also have problems with the principle of legality, or?
Well, I mean, if we look forward, I guess that there could be no problems, depending also on the national laws that we are able to identify. Like, I know that Lithuanian law makes explicit reference to social and political groups. I mean, the Genocide Convention only set, I would say, a sort of minimum standard for all states who have ratified. I mean, we are also talking about customary international law, jus cogens, so it's not really important if you have ratified the convention per se, but I mean, out of this minimum standard, you can always expand, you can introduce other groups, you can change, you can also delete the reference to as such, you can delete all possible things that like a state think might impede, like disrupt their policy. So in this sense, for future interpretation, I do not see any specific problem, but still, like the issue related to as such, I think it's still relevant in order to be able to identify and to distinguish cases of genocide from cases of other international crimes. I mean, the label of genocide is quite relevant, not only from a legal point of view, but also from a social point of view. So I'm not sure, but I mean, I'm open to obviously discuss it, if expanding so much the definition of genocide would necessarily be good, till like we almost come to see persecution and genocide so close that it's really hard to make a distinction. Yeah, there is this difference with the intent to destroy, the discriminatory purpose, which is necessary in case of persecution, but still, like, I would be careful in expanding too much, but in this sense I see no problems related to interpretation for future times. And just to briefly comment on what you have asked before related to the issues. I see the problem of identify a part of a part of a part. Like, I think this is a problem. I mean, I think that in this sense, the real task of a court, for example, called to judge a case concerning genocide, is being able to identify the targeted group. Because if we go with part of a part of a part, then like even a small part, I'm not saying that targeting a very small part is good. It's for sure a crime, probably it's crime against humanity, but still, like, I think that the most important task for a court is to be able to identify what is the targeted group. Are we talking about like European Jewish people? Are we talking about national? Are we talking about a regional group? And so this is, I think, an important task for a court, to identify the biggest picture in order then to be able to define what is a part of that one.
Okay, thank you very much. Now I would like just to, I would like to ask, do we have a question from the room?
Thank you for your thoughts, for your report. It was very interesting. I was wondering, what do you think of this thing? When we talk about legal certainty, it is sometimes good if everything is written down. And what do you think, perhaps for the sake of the legal certainty and for the future, do we need to amend the convention or to draft a wholly new one? Or can we just, at least from today to the future, rely on the interpretations? So change of the convention, or rely on interpretation as we understand it nowadays, including these social and political groups as well. Thank you.
Thank you very much. My question would be, or rather comment, and I would like to hear your views on it, because I do agree that this is indeed a discussion whether the Genocide Convention is a living instrument that has changed within the past 60 years, and what had been understood as national, ethnic, racial, religious groups at that time right now might also include political. But the question here is, and it comes also from the dissenting opinions of judges to the Drėlingas case, whether Drėlingas at the time when he was committing his crime could have understood and could have interpreted the convention as we are interpreting it right now. And of course I do agree, and I believe so, that right now targeting a political group should be considered also a genocide. But was it the same, or was it by anyone interpreted in such way, and could have he foreseen it in 1956 when he was engaging in that? I would like to hear from you on that question. Thank you.
So if I could respond to the second question, because it's kind of seems interesting to me, is that the foreseeability and the change of interpretation, is it something that actually belongs, is there a right to the defendant to know the interpretation beforehand? I think no. If you think, for example, on the Nuremberg Tribunal and the concept of crimes against humanity, could the defendants there actually in 1939, when, and even before of course, but there was a cut-off date 1st September of 1939, put on there when the war started, that after that, killing of your own people, your own mentally disabled people or your own political opposition, that this is a crime against humanity. What? Who had ever heard before that you could be punished for that by an international court? What the international court said that, no, this is just a new interpretation, you know. It's basically war crimes, but just against your own people. So what's the difference? And even more so, even more controversial, of course, it goes for the newly invented crime of aggression or crime against peace in the International Military Tribunal. At least in Estonia, the Supreme Court has on numerous occasions in normal, everyday domestic crimes said that you are never protected from a court coming to a different conclusion, giving a different interpretation to a legal norm than there was before. So I think that this is not in the protective area of Article 7 of the European Convention of Human Rights. Thanks.
Well, yes, as regards the first question of legal certainty, I would say, you know, it is a great asset that finally, after decades of having the genocide convention, of having reached a certain point, at least a certain degree of legal certainty, now that there is some international jurisprudence on the matter, and we should not give up that state of legal certainty. Of course, there are loopholes for the future, but those loopholes should, I think we are better off closing those loopholes by amending crimes against humanity. Okay, that's my brief thoughts about this, about your question. And the other one, genocide at the time. Was there genocide at the time, and if so, was it foreseeable to Drėlingas and other middle-level or low-level perpetrators and henchmen of the crimes being committed? Now, of course, this is a very difficult question. If really at the time, especially the actions of Drėlingas amounted to assisting to a genocide. I think the biggest obstacle in affirming that is what has already been raised, the problem that has already been raised by Gustavo, especially the as such criterion, the criterion of genocidal motive. This is really a weak point. This is the biggest elephant in the room, so to speak. So I would be rather reluctant to hold the Drėlingas actions as actually amounting to being accessory to genocide. And if so, then the foreseeability problem is already answered that as well. If there was not a crime of genocide, if he did not, well, aid or abet to a crime of genocide at the time, then of course there was no foreseeability. But this is rather preliminary, this remark, and I need to know more, especially the historical circumstances, and this is just an interim result from my perspective.
Okay, so thank you for the questions. As for the first one, yeah, I agree that the idea of like closing the loopholes through crimes against humanity could be like maybe the best way in order, because we have this treaty which has incredibly survived for so many years. Now we have this definition which is also customary international law, jus cogens. So I agree. But then, I mean, I think there might be chances to amend, but in a specific way. Like, I don't see any chances that all state parties will agree to a new expanded convention. But I mean, Article 41 of the Vienna Convention on the Law of the Treaties allows inter se modifications, so modifications like among state parties to a convention which do not include all the state parties to the convention. And then there are some requirements about the fact that the treaty does not prohibit an inter se modification, that it does not affect any rights of the other parties, and in this sense I don't see any specific problems in expanding the notion and the groups, the protected groups. But I mean, it depends on the political will of states to expand. So, but I mean, I see some possibility only in this sense, because otherwise I see really difficult that so many states would agree to a new expanded convention. And for the second question about forcibility, well, like my position, I think it's quite clear. I think that there was really difficult, like, no, I don't want to say no forcibility, but it was really hard to see it foreseeable for the two reasons I try to point it out, both for the, first of all, the as such interpretation and the idea that you can have ethno-national political genocide. It's already like hard to foreseeable, and also for the interpretation of in part. And I think that actually the European Convention protects this right of the accused person, of the perpetrator. In this case, I mean, the court has been quite clear that you are not protected from subsequent clarification of the existing law. But I mean, from my point of view, this is not a subsequent clarification. This is an expansion of the law. So I would say that in this sense, the convention and the court protects people from, protects all of us at the end from a subsequent development in the law that are applied retroactively.
Let me introduce you our next speaker from United States. So Professor Henry Theriault. I'm not sure if I pronounce that correctly. It's French, so excuse my spelling. He is a professor at Worcester State University at United States, and he will be delivering a speech, Repairing the Irreparable, the Passage of Time and the Obligations of Perpetrator Groups. So please, Professor, the floor is yours now.
The Drėlingas case can be seen as an important corrective to the Vasiliauskas case by recognizing as genocide that which, from a common sense perspective, we perceive as such. The decision allowed application of the UN Genocide Convention to events that occurred decades prior to the Lithuanian law of the 1990s that specifically included political groups as possible targets of genocide, something the UN Genocide Convention famously does not. The Drėlingas decision depended on the same basic logic as the Srebrenica case, in which genocide was determined to have occurred through mass murder of a relatively small percentage of an overall target group. But that small percentage had a special role in the future viability of the group as a group. As with the truth table method and formal logic, this line of reasoning yielded the proper result, but did not reflect what truly made the events in question genocidal. It was a legal maneuver in a situation in which the law itself was the result of political maneuvering that excluded certain groups out of expediency. The obvious moral motive for why the case was brought at all was that a political group was destroyed, and that the destruction of a political group should be considered genocide. The reasoning, but not the conclusion of the Drėlingas decision, has two other related problematic aspects. First, laws against genocide, which should focus on states and other groups as perpetrators, actually focus on individual perpetrators and thus contort the reality of what genocide is, a collective crime. The UN Genocide Convention is, in many ways, not about genocide at all, but a reductive adaptation of criminal law focused on individuals. The vast majority of legal action against genocide is, in its essence, the equivalent of typical murder, rape, and related trials. The added dimension is proving that the offenses happened as part of the commission of genocide. But in this sense, genocide is simply a condition marking the seriousness of the individual offense, not the point of the legal process. But if by the logic of the Drėlingas decision, the direct victims of killing are victims of genocide precisely because of their relationship to the larger group, and that is why their killing is genocidal, should we not also see the state or other group that individual perpetrators acted as a part of as the true perpetrator of a given genocide? should not conviction of an individual perpetrator entail the much more important culpability of the state or collective and result in sanctions against the state or collective that perpetrated the genocide? Yet, it is vastly more difficult, if not virtually impossible, to achieve punishment of a state or require reparations by a state perpetrator than it is to punish individual members of the perpetrator group, which does little, if nothing, to mitigate the impacts of a genocide. It is these impacts that lead us to the final problematic aspect of this decision. The real issue is not the retroactivity of application of a law to a genocide, but on the contrary, its prospectivity, that is, application of the law to the unfolding subsequent process of genocide. While murders, rapes, and so forth are discrete events, genocides are not events, but processes. What is more, while the action by a perpetrator and the event of a murder, rape, or so forth they commit are coextensive, this is not the case for genocide. The collective actions producing a genocide are typically much shorter in duration than the genocidal process itself. This could be seen as a function of the intensity of genocidal violence, which cannot be registered in the world as in as short a time as the acts of genocide typically take to commit. Just as a flood might not manifest until days after the rain supplying it with water has fallen, a genocide committed through actions that might take years actually lasts much longer. To recast the continuing violation argument of Frederick McGray in a more complex fashion, genocide as a process inevitably overspills the temporal boundaries of the actions producing it. As an aside, the exception is genocide by attrition, in which actions are intentionally slowed in order to obscure their cohesive wholeness. In this way, the Drėlingas court should not have been concerned with whether actions decades ago could be subject to a law against genocide, but rather should have assessed whether the process of genocide initiated by them is still unfolding. This is not simply about consequences that follow from an action, but the completion of the action itself. It is certainly possible, when examining the challenges and vulnerabilities of Lithuanian cultural and political cohesion and viability in the Soviet and post-Soviet eras, to conclude that genocide continued forward well past the 1990s law. While this might appear to violate various legal principles and conflate a process with its consequences, there is a test of this approach. Unlike individual acts of violence, in which there could be persisting consequences, but the action itself is complete and irreversible once committed, one cannot take back a murder or rape once it is committed. Genocide is quite different. Counteractions can be undertaken to interrupt the completion of a genocidal process, even if the acts producing it have concluded. While misconstrued typically as reparations, these are in fact interdictions against the trajectory of a genocidal process. For this reason, the typical legal as well as political and ethical objections to reparations based on the passage of time reflect misunderstandings of the metaphysical nature of genocide as a process. Repair is actually intervention, not something done after the fact, as is individual criminal justice applied to cases of genocide. However, morally right individual cases are in a limited sense. These problems show that the entire Western liberal individualist legal tradition cannot adequately address the challenge of genocide. Rather than trying to force quests for justice in the face of genocide to conform to this tradition, the challenge of genocide should drive radical new developments in concepts of law and justice.
I see that our time as panel is up, so I'd like to thank everyone for the discussion, for your interventions, and well, I think we have raised a lot of important issues, and I guess that the discussion about genocide, about legal definition, political definition, about amendments and interpretations will go on perhaps for a long time. So thanks for your input, and let's give the floor to the others. Okay, thank you very much.
Thank you very much. Ladies and gentlemen, I would like to welcome you on the second panel for today's conference. I would like also to take a moment to thank you, Mykolas Romeris University, and especially Dovilė for organizing the conference. I'm very happy to be here. It's my 4th time in Lithuania, and every time I'm coming here, it's getting a better experience for me. So thank you so much for that as well. Today we will be talking about, on the second panel, on the history behind the Drėlingas case, and I'm really happy to be moderating this panel, and we are strict on time, but I hope that with the relaxation from not airing this online right now, we might have a little bit more time also for our speakers and for the discussion on this important issue. So without prolonging, I would like to welcome the first speaker, and this is an honor and privilege for me to welcome Professor Žilinskas, who is currently the Dean of the School of Law at Vytautas Magnus University, but who was the President and Judge of the Constitutional Court of the Republic of Lithuania. And I hope that he might share some background information. I'm really delighted to hear about the 2014 Constitutional Court decision that led us to the Drėlingas case and led us to see this landmark, and I'm not afraid to say this, groundbreaking judgment in the European Court of Human Rights. So I don't want to take any more from your 4 minutes, so the topic of the presentation will be Behind the Drėlingas case, Concept of the Soviet Genocide in Lithuania in accordance with the ruling of the Constitutional Court of 18th of March 2014.
Thank you very much, dear friends and colleagues, ladies and gentlemen. First of all, I would like to thank the organizers for inviting me in this important conference, and I'm really happy to present you at least one element what was behind the Drėlingas case judgment in the European Court of Human Rights. Because, as you can see in this judgment, there are a number of references to that Constitutional Court ruling, and I also hope to answer to at least some of the questions raised in the first panel, of course, from national perspective, and how. Do we understand those sensitive questions? Of course, I can recognize that they are disputable, debatable issues in the doctrine of international law. But you know, sometimes the difference between judge and scholar is that judge at the end should take the decision. In balancing of course legal values, but should take the position. So therefore, and I am going to present you this position. First of all, as you can see from the judgment in the Drėlingas case, the ruling of the Constitutional Court is seen as a sort of general measure to ensure that national practice is in line with international law, in line with the European Convention of Human Rights. And of course, therefore, I just, as my first point is that this ruling was a ground to correct both national judicial practice, but also it was one of the reasons why we see the different or the changed attitude in the Drėlingas case in comparison with Vasiliauskas case. My second point is that the Constitutional Court has faced two challenges. The first challenge was the consistency between the Constitution and international law in deciding on genocide definition, because the case was about constitutionality of the definition of national definition of genocide, and as the point of departure, the court developed the doctrine of constitutional minimum standard of international law as constitutional minimum standard for human rights protection on national level. Therefore, the provision of criminal procedure code has been found unconstitutional. That was the reason. Challenge number 2 was, to preserve national constitutional identity. National constitutional identity arising out of the declaration adopted by the Lithuanian freedom fight movement, that is the resistance movement, that has been recognized as one of the fundamental constitutional acts of the state of Lithuania. And you can see there two constitutional traditions as a cornerstone even of national constitutional identity. I mean, expressed in that declaration, in the declaration of the organized military resistance against the second Soviet occupation. The first is respect for international law and human rights. Maybe not all of you are aware, but by that declaration, the Lithuanian freedom fight movement also expressed its adherence to the Universal Declaration of Human Rights. So, and the second, sometimes we call here in this region as the legacy of double totalitarianism. That means that inconsistency of both the Nazi and Soviet ideology, and of course their logical or as a consequence the assessment of their activities with the Constitution of Lithuania, because in that declaration both occupation regimes had been condemned, and by way its particularity of the Lithuanian constitutional tradition that the Communist Party has been prohibited on the constitutional level. And therefore, as a part of solution, I would like to mention 4 points. First of all, Lithuanian Constitutional Court came because, please understand me, it's impossible to, in 5 minutes, to provide with all the argumentation of the court. So the first, let's say, a solution was that the definition of genocide as provided currently in the criminal code is consistent with the Constitution. Because wider definition is a matter of national discretion, and the Lithuanian Constitutional Court followed also the example of number of states, among which Estonian, I think, was mentioned in that ruling, because the position of the Lithuanian Constitutional Court was that in defining genocide, the state can also take into account its specific historical, let's say, heritage. The second solution was inconsistency of retroactive application of a part of genocide definition, namely the so-called definition of political and social groups, because really that was not consistent with the concept of international law as a constitutional minimum standard. So you cannot apply retroactively the responsibility for extermination of political and social groups. However, the third point, that the Constitutional Court affirmed the prospect of a possibility to apply responsibility for extermination of political group, provided two conditions are met. First of all, there is necessity to prove the so-called genocidal intent to exterminate a part, because under the Genocide Convention it is also in part, destruction in part, a part of national group. And the second condition also to prove that this group is so significant for the survival of the protected group, of the national group, that really it is so essential for its survival. And here the Constitutional Court, of course, left the final decisions for the courts of ordinary jurisdiction, for criminal courts, namely to prove genocidal intent and the significance of this part of national group. But the Constitutional Court also mentioned certain criteria for this possible assessment. Why partisans can be assessed as significant group? Because of the presence of consistent systemic and methodological practice of their extermination. Because they were significant because they acted on behalf of the whole Lithuanian people, for example, in adopting that kind of declaration. And the policy of their extermination was also more than clear. I mean, that was namely extermination, taking into account that no international protection was granted as for combatants. And there was also reference, you know, sometimes you can see this reference to certain also national groups like bandits, terrorists, and so far. And also special extermination squads had been operated. And therefore, the Constitutional Court assumed the possibility to assess on those conditions the extermination of Lithuanian partisans as a crime of genocide. And the last point, the Constitutional Court also stressed that under the rule of law, no impunity should take place. So if this genocidal intent is not proved, then the Lithuanian national law enforcement agencies should try to assess the same actions in the light of the definition of crimes against humanity or war crimes as appropriate. Thank you very much, and I'm really sorry for maybe exceeding my time.
Thank you very much. I didn't mention this before, but I am on the strict schedule here, so we have to follow the rules that were set for us. Thank you very much, Professor Žilinskas, for this very interesting introduction and showing those 4 points that were standing behind the decision of the Constitutional Court. Now we will be moving to the presentation given by Dr. Elina Grigorebara. She's an assistant professor at the Department of Legal Theory and History at the University of Latvia, Faculty of Law, and she researches in the field of legal theory and legal history, and also philosophy of law, where she teaches also those topics at the University of Latvia. Dr. Grigorebara will be speaking to us, telling us about criminal prosecution as a component of transnational justice, and dealing with Soviet genocide in Latvia. So we'll get hopefully some perspective from a neighboring country on how the same problems are resolved in Latvia.
Yes, thank you for the kind introduction. Thank you, organizers, for inviting me. And so yes, I will give a very short insight on what is happening in Latvia and what has happened in Latvia in dealing with Soviet genocide. So I will shortly address just 2 issues, development of legislation on genocide in Latvian law and court practice, what kind of arguments the courts have defined. The crime of genocide was introduced into Latvian law in 1993 as an amendment to the Criminal Code of 1961. And the Supreme Council added a new chapter to the special part of the code. The title of the chapter was Crimes Against Humanity, Genocide, Crimes Against Peace, and War Crimes. But the chapter included only 3 sections, and one of them, section 68 with index 1, was devoted to genocide. The title of the section was, I quote, Crimes Against Humanity, Genocide. So firstly, the Latvian Criminal Code did not distinguish genocide from crimes against humanity. National law had merged them together in one section. Secondly, the definition of genocide was extended to social groups and people with common conviction, so to political groups. And third, the list of prohibited activities was also extended with restriction or deprivation of economic, political, and social rights. And I have to add that in all genocide cases in Latvia, which were investigated and tried in Latvia, it was done on the basis of this section, because the new criminal law of Latvia provided for a more severe penalty, and so the article of criminal code was being applied in all the cases. And so in 1998, new law was passed, and the new Latvian criminal law firstly resolved one ambiguity. It distinguished the crime of genocide from other crimes. And since 1998, genocide is defined separately in a separate section, 71, and the title is clear, genocide. But the two additional protected groups, social and political, remained in the law, though the list of the prohibited activities was shortened. Restrictions and deprivations of rights were removed in 1998. And the final amendments were made to this section in 2009. And in 2009, the legislator excluded these two additional groups from the scope of Latvian criminal law. And thus, since 2009, the definition of genocide in the Latvian criminal law is the same as one in the Genocide Convention. So we don't have this broad definition anymore. It was only till 2009. And now very shortly on court practice. None of the provisions of the criminal law, nor of the criminal code, nor criminal law, have been assessed by the Constitutional Court of the Republic of Latvia. Consequently, we can talk only about conclusions by the courts that tried the genocide cases, and those were regional courts and the Supreme Court of the Republic of Latvia. And I will mention a few articles and conclusions which were made by regional and Supreme Court. The first one, Supreme Court asserted that crimes against humanity, including genocide, that was the wording of law, well, crimes against humanity, including genocide, they existed not only if repressions are based on race, ethnicity, and religion, and the Supreme Court referred to Article 6c of the Nuremberg Statute in order to back this extension of the genocide definition. In other case, the Regional Court of Kurzeme claimed that the characteristics of groups named in the Convention cannot be considered as an exhaustive list. And the court stated that historical experience proves this. In different national laws, the protected group list has been expanded, and the regional courts referred to Belarus, France, Estonia, Germany, and Lithuania, and also referred to the aforementioned Nuremberg Statute, Article 6c. And the final conclusion was that the extension of the constituent elements of the crime of genocide did not lead to contradiction between Latvian criminal law and international law. And the third one, also argumentation from regional court, was as follows. The Convention on Genocide provides previous historical experience. However, new experience has been gained since the convention was drafted. And the most characteristic feature of crimes against humanity, genocide, is their perpetration against a group of people, which can be formed according to certain features. And in this case, the regional courts referred to Article 2 of the Universal Declaration of Human Rights, on prohibition of discrimination, which inter alia prohibits discrimination on grounds of social origin. And consequently, the regional court didn't see a legal problem in the fact that Latvian criminal code, compared to the Convention on Genocide, specified the group of people against whom genocide can be committed. So court saw this criminal code as specification, not expanded version of genocide. And
apologize.
Yes, an ending conclusion. So the problems we encountered in investigating and prosecuted Soviet crimes have not allowed us to fully achieve the goal, implementation of material justice and prevention of impunity. So I believe we should put more emphasis on other elements of transitional justice. For example, truth-seeking commissions and things like that, because I believe there won't be much, or if any, cases of Soviet genocide in Latvia anymore. There aren't any cases pending, so I think the time has passed for that. Thank you.
Thank you very much. Now we are moving to Professor Monika Karaniauskaitė, who specializes in Soviet and post-Soviet history, law, gender, and criminality. She works at the Law Institute of the Lithuanian Center for Social Sciences, the Lithuanian Institute of History, and she has an impressive history of international scholarship, including postdoctoral position at the Yale University, and she was also working for some time in Switzerland as well. Her research interests cover criminal prosecution systems in Soviet and post-Soviet Lithuania, and also other post-Soviet republics, and also anti-Soviet resistance, trials, political trials, deportations. Now we are looking forward to hear on historical circumstances and representations behind Drėlingas case, the process of the Sovietization in Lithuania.
So thank you very much for this introduction, and I'm very, very happy to be here. Thank you for the organizer. First of all, I would like to do a short disclaimer. I'm not really an expert on the partisan war. I was more focusing on armed resistance, but still I will try to shape the discourse and say just the main trends in the research and in historical memory. Well, first of all, what is this? It is very difficult till today to talk about these issues in Lithuania, because the discourse about the partisan war is still very much shaped by the trauma, by the traumatic experience. There is still this feeling, at least in a part of society, that it is lacking the justice, that Soviet crimes themselves is somehow the failure, or not bringing the justice for the Soviet crime victims is some sort of the failure of the de-Sovietization in Lithuania. That's the discourse. I'm not questioning is it objective or not, but I'm just saying about the discourse here. So the trauma, I think, prevents the research sometimes too, and more like rational understanding of these phenomena. So first problem here, what historians don't have till today the consensus on is what was the Lithuanian armed resistance of 1944-1953. They have actually different views on the phenomenon. The second problem, who the Lithuanian armed resistance was representing. The third problem, Lithuanian armed resistance and war crimes, meaning the crimes that partisans themselves might have committed. And the fourth problem, the historical memory, of course. So the first problem, there are, I would say, maybe three main perspectives how historians see this phenomenon today, but they have different views. The first view could be said that, yes, it was a typical partisan war, like with all that typology of the international studies and discourses taking into consideration, or the status of that war, the legal status, who they were they regular army or were they partisans, who they represented, is not just questioned. Historians just collect a bunch of facts but don't make any conclusions. The second is that Lithuanian armed resistance were military forces that were represented actually in Lithuania, and that was sort of Lithuanian volunteer army, which organized spontaneously because the political elites were destroyed already during the first Soviet occupation. So it was like spontaneous will of Lithuanian nation to resist the Soviets. It was, for instance, Bernardas Gailius' perspective, Lithuanian historian, and the third perspective is that Lithuanian armed resistance is military forces or even some sort of underground state. it's Aistos Petrauskienės view. The second problem, as I said, is that we can talk about the qualitative representation, but the quantitative is still questionable, but there are some numbers already known. So 25,000 of partisans and their supporters died in the fights, according to the Genocide and Resistance Research Center of Lithuania. Well, then these numbers, of course, should be compared with the numbers of Lithuanian inhabitants, and we should find some sort of methodology to really understand what is the representative group in the quantitative numbers, even if that maybe not matters so much as qualitative representation. Another number known by the mentioned center is that roughly 50,000 partisans were active, and plus 50,000 of people was the active support network. Numbers are not final. Historians are still working on those. Then, well, what is also important to see the social background of partisans and their motivation is historian Dainius Noreika is working on it. Now it seems that a majority of people were rural population, but well, it is still, the research is not final here. And yes, then the question about other minorities in Lithuania and so on still remains open. The third problem, I would say, that Lithuanian armed resistance and war crimes is that, well, yeah, there was the Soviet narrative, which is already, I would say, very much not as objective by Lithuanian historians, that Lithuanian partisans were sort of people who were committing crimes of Holocaust and then just hid in the forest and continued the resistance. So this view is, I think, more or less not objective and denied by historians, but still, of course, individual participants could be involved in the Holocaust from the Lithuanian resistance, and those things should be addressed. Then crimes during resistance, meaning when there were, as in every military conflict, there were killings of civilians, and we should really see which case was the civilians, which case was actually some sort of Soviet armed personnel. For instance, one example, the chair of the collective farm, it is not clear if it should be treated as a civilian or not, because they were like loyal supporters of the Soviet regime. They were armed and maybe sometimes even more remind the armed forces than just civilians. But to our understanding, what was the leader of collective farm, it comes from the 80s, so it's just different than in the 50s or 40s. Then yes, as I mentioned, justice is needed for all victims, and yeah, civilian representation. And the third problem here, I think, is the problem of historical memory. First of all, the Sovietization of this narrative, that was, the story was hidden and the memory was just suppressed for so long, people just didn't talk about it. And that also is very much shaped by the trauma, then the victimization and heroization of the narrative. So the narrative about the partisans is seemed as extremely white or extremely dark, but understood. I mean, historians try to understand the objectiveness of it, but sometimes it's very difficult still to talk to general publics about these issues, because you are kind of labeled maybe as Russian agent for only raising the questions. And then the politicization of the narrative, because it's crucial for Lithuanian state. And I'm not questioning the official narrative here, but I'm just trying to say that I think sometimes it puts the additional pressure for historians and researchers to really evaluate that topic, because it's very hot political issue of today and a part of the identity of Lithuania today. So I here just raise questions. I'm not making the conclusions, and maybe provocating a little bit just for discussion. Thank you.
Thank you very much for this interesting discussion from the historical perspective. And now we are moving to Professor Justinas Žilinskas, who is a professor of public international law here at the Mykolas Romeris University, where he teaches, as far as I know, international humanitarian law. And I have to admit that we've met some time ago in Wrocław, and I'm really happy to be sitting today again with you on this panel. Beside his academic work, Professor Žilinskas worked at Lithuania's Parliament Legal Office during the EU accession process, worked also in various government level working groups, and also in national, international humanitarian law implementation commission. The scientific interests of Professor Žilinskas are mostly oriented towards international humanitarian and international criminal law, with, of course, emphasis on Baltic Sea experience. Today we will hear from Professor Žilinskas on closing the loophole, Drėlingas, and I'm sorry for my pronunciation of this very difficult Lithuanian last name, Vasiliauskas, cases from the crimes against humanity perspective.
Thank you very much, Madam Chair. I'm just starting my countdown to keep the time. Okay, so it's already a few times sounded the issue that crimes against humanity. When we're speaking about Drėlingas and Vasilauskas cases, we kind of thinking that why it was not crimes against humanity. And this question was exactly the question that came to my mind almost immediately when I started to show interest in those cases, especially having in mind that crimes against humanity looked like an ordinary choice, having in mind that it was already formed in 1945, London Charter, International Military Tribunal, adopted by the United Nations General Assembly as the principles of international criminal law, and things like that. But for some reasons, Lithuania haven't got the crimes against humanity option because it wasn't in our law. In comparison with Latvia, that made, I think, a very clever decision by merging those crimes together and avoiding this problem. Okay, they avoid one problem, they got another problem, but still. So then I started to think, why it happened. So is it just because the power of the word, that the genocide, you know, is a powerful word. When we're talking about the genocide of some group, we think that's something really horrible. And crimes against humanity, well, what are exactly crimes against humanity and things like that? Having in mind that both Vasilauskas and Drėlingas cases, we have this problem of interpretation of political genocide. So then I started to consider whether in material sense those two persons, Vasilauskas and Drėlingas, could have been tried for crimes against humanity and not genocide, and subsequently maybe then they would not have faced the European Court of Human Rights because of this, that crimes against humanity were already established and genocide was still with all this complicated definition. By the way, I'd like very much Andreas naming that this is political definition. This is not legal definition. It's definitely, well, flawed. So to answer this question, I would like to compare those two types of crime and to see where they differ. And from the first thing, it looks like very clear that crimes against humanity definition looks to be wider because it has no limitation towards designated group. Moreover, it does not have a requirement intent to destroy the group whole or in part. Then why not to go ahead with crimes against humanity? And then I thought that the same thing, definition of victim and definition of intent, might be the problem in Vasilauskas and Drėlingas case from the other point of view. Okay, so without going deep into elements analysis, I would like to pinpoint a few things. The first, when we're talking about crimes against humanity, we're talking about civilian population or attack against civilian population. And despite of the case law and IHL sources that provides that civilian population may entail non-civilian elements, which do not deprive civilian population from protection, the question remains, can a person belonging to the armed resistance and not being hors du combat, so wounded, sick, surrender, will be protected by crimes against humanity? Could he be considered as part of civilian population? And that's exactly Vasilauskas case situations. Two partisans in an active combat phase, shot by the members of repressive force. Could we consider them as the victims of crimes against humanity? And there are opinions that in London Charter, while describing crimes against humanity, there was double character of the crime, making difference between ordinary crimes against humanity and crime against humanity of persecution, again mentioned today. But the problem is that specific law is very scarce and related to persons who are not in active combat, but they were hors de combat, for example, members of resistance and other forces, sick or wounded or already giving up arms and so on. Therefore, especially today, I would doubt whether crimes against humanity, even under Rome statute, do protect members of political group which are actively resisting with arms, even though their destruction is part of political group's persecution. So I don't know whether, for example, you can hold, especially from the point of view of international humanitarian law, a person who is resisting to be a victim of crimes against humanity. And therefore, it looks like that we might have a loophole, because members of political and other groups, social, targeted for destruction, could be killed legally if they are resisting destruction with arms. And coming back to cases and the discussion, it would seem that Vasiliauskas' case would have been lost anyway, whether Lithuania would have qualified as genocide or crimes against humanity. And Drėlingas' case also might have been different, again, because Vanagas was caught hors de combat situation. Moreover, afterwards he was tortured and many more abuses were committed towards him. So it fits under crimes against humanity umbrella. And ironically, European Court of Human Rights, by supporting genocide umbrella as well, in Drėlingas' case, also supported crimes against humanity umbrella. So my guess that it might be also exactly the case why it happened, because European Court of Human Rights saw this loophole and understood that perhaps in a case of justice it needs to be closed, yes, and it comes in line with the Judge Kūris dissenting opinion in Vasiliauskas' case. Thank you very much. Sorry for exceeding time.
Thank you. Thank you, Dovilė, for supporting. It is always hard to stop listening to interesting stories. Thank you so much for your presentation. And now we are moving to question round. And I would like to ask first whether anyone from the room would like to ask the question. If not, I have some prepared questions based also on what we were talking during the first panel, but also what has been raised today during the second panel. One of the issues that was not addressed, almost not addressed by the majority opinion in the Drėlingas case, but was raised by Judge Ranzoni in the dissenting opinion for this case, was the question of the time frame. And it was also raised today here in this room that we have certainly a problem with when exactly the crime has happened and how do we interpret this from today's perspective. But there is also another problem with the time frame. Judge Ranzoni raised the issue that in 1953, the active resistance of Lithuanian partisans has ended. And Vangas was captured in 1956. And allegedly the genocide happened at that point. The question that was raised was by Judge Ranzoni was whether if it happened in 1985, for example, would we still think that capturing a person that in 1953 was a member of active resistance in Lithuania would be also adding to genocide if it was those 30 years ago? I can relate this to the Polish government, refugee government in London that has ended in 1990. I would assume that after the Second World War, immediately killing the president of Poland in refuge in London could have been interpreted as genocide or any other crime. But in 1985, again, perhaps killing the president of Poland in refuge, that was from the international perspective, a minor issue, would not be interpreted in the same way. So does it really matter whether it was in 1953 that the resistance, allegedly, as far as I am aware of the Lithuanian history, has ceased, and the person was killed in 1956, or it doesn't matter at all when we are thinking about the time frame? So it would be a question, I guess, to anyone who would like to respond.
Whether the time matters. No, it doesn't, because in the Republic of Latvia, the doctrine of state continuity is established in a constitutional level. And that means that the state of Latvia didn't come to end, but it continued throughout the whole period of occupation. So the former citizens of the Republic of Latvia had constitutional duty to protect the Republic throughout all occupation period. And I believe even in 89 it could be done. So it doesn't matter if it was in 46 or 86, it still was the protection of Latvian state as a duty, as I said, constitutional by former citizens.
If we can try to answer this question, of course, I hope Justinas will add from criminal law perspective. But looking at the ruling of the Constitutional Court, I would say that we could come to a different conclusion than in Latvia, really, because the Constitutional Court also referred to the specific time frame, where indeed the foreseeability element could be present, that, you know, in 1953 and even in 1956, it was reasonable to think that the person could realize that he takes part in a common plan against partisans as a group. And he can, of course, he could be fully aware about extermination purpose of the partisans, about significance of this group to the Lithuanian national, to Lithuanian nationals. And of course, he could be aware about the general Soviet policy. I didn't mention that before, but the Constitutional Code also referred that certain people were treated as unreliable nations. That was deliberate state policy of the Soviet Union, and as a decision was to exterminate certain people as a whole. For example, Lithuanian Constitutional Court mentioned Chechens, English people, Crimean Tatars as in general context, and or in part like Lithuanians. So in 1956, it was still reasonable to foresee the context or the consequences of the deeds performed that. But we have also different practice of the Lithuanian national courts, I mean ordinary courts in Mykolas case, yes, if I am right. So the actions made in 1967 or something like that. So that was beyond reasonability, but still I think it's my personal opinion, I'm not going to criticize Lithuanian national judicial practice a lot, but still I think that this kind of activities, not specifically maybe in this case, but we know that certain Lithuanian courts or law enforcement authorities refused to prosecute those who probably committed a crime against humanity, that is political massive political prosecution of dissidents, for example. So maybe in that category it could fit.
Thank you.
I could just add a little bit from the standpoint of the Soviet legal order or regime that yes, Stalin dies in 1953, but the legal order in Lithuania, I would say, changes to post-Stalinist or Khrushchev era only later. So the new criminal code is adopted in only 1962, and this still a couple of years after the Stalin's death, there's still old legal order, and this system continues and understanding and labeling of partisans continues. So I think maybe that is also should be taken into consideration a little bit.
I think that this thing that Vanagas was hunted as long as he could be got, it clearly shows that this was intention to deal with those, to continue with the repression towards these people. So basically, by that time when he was captured, he was not resisting anymore. He was already ailing, if I'm not mistaken. He was ill, basically. But still, I can't see why, let's say, this genocidal intent, if we're speaking, or persecutions intent, wherever we will take crimes against humanity, why it should be limited in time. So, for example, if there's a policy, let's say with the Polish government in exile, if there's a policy to destroy this government, so does it make a difference when you do it? Because it's just a matter of the broader picture. And I think in these circumstances, broader picture indeed plays into the hand of this so-called political element that is necessary for both for genocide and both for crimes against humanity. That when already person who is not doing anything wrong and is not capable to do, but you are still going for it, and even afterwards torture and do a lot of terrible things. So it was the same not only with the Vanagas, but also the leader of the resistance, Jonas Žemaitis. He was caught also a little bit later, when already all this active phase was over. But still, it was a matter of continuing destruction of those who are resisting.
Thank you very much. Do we still have time for questions? Okay, so I will ask once again if someone has questions. Please, Mr. Parvas.
If I understood it correctly, then one of the issues for Lithuania was that in your criminal code, at least for a certain time, there was no definition of a crime against humanity. But then again, crime against humanity was punishable universally under international universal norms of international law. And your constitution, was it Article 135, says that you're recognizing universal norms and principles of international law. Wouldn't it have been possible to prosecute a person based on directly on universal definition of a crime in Lithuania without having a norm in written down in your criminal code based on the constitutional reference that you have in Article 135?
Unfortunately, my answer is no, because how to prosecute when you don't have criminal sanction in your criminal code? But the difference between certain rules of international law, but certain rules cannot be implemented directly because of their character. So, of course, we did recognize even at that time under the Constitution the concept of crimes against humanity, but practically it wasn't possible to prosecute because of absence of responsibility defined in criminal code. But yes, maybe in certain time, had the Lithuanian court received the complaint, it could, for example, conclude that there was a legal gap in criminal code that should be treated as unconstitutional. But we hadn't received any complaint, so the issue really in the law enforcement practices, that's sometimes a sort of inertia, because the only law on genocide was in our legal system. So everybody was tried for genocide without really examining the issue of genocidal intent. So that was the problem. But yes, thank you.
Do we 5 more minutes, okay? Once again, any question from the room?
So first of all, thank you very much for all these interesting speeches. I have a question, I think, directed to Professor Žilinskas, sorry if my pronunciation is not correct. Would it be possible, could you imagine that Drėlingas and Vasiliauskas would be prosecuted for war crimes? Like you could have imagined this, and also like for crimes against humanity, like maybe not directly in these 2 cases, you could imagine, if you have the provision, obviously, so this is not the case at that time, if I have understood correctly, but you could imagine that there were crimes against humanity against the whole Lithuanian population, like deportation, persecution, maybe even extermination. I mean, I'm not really so familiar, so it's hard for me to draw any conclusion, but I mean, one of these crimes against humanity. Thank you.
Well, from the point of view of war crimes, perhaps that would be complicated with Vasilauskas, because, as I said, it was a military, let's say, operation, and he was shot. So, let's say from the war crimes, it's not illegal, let's say, to shoot an armed opponent. With Vanagas case, yes, it could be war crime, but the war crime of different character. It perhaps would be a war crime, for example, of torture, let's say, in a way. But the problem is that by that time, again, Vanagas was already, as I said, hors de combat. So anyway, he should be treated as a captured combatant, and this is one of the again problems and one of the things that shows the Soviet policy's intent is that they were not giving any status to these people. They were not considered as combatants, they were not considered as prisoners of war, and so on and so forth. So that's why, let's say, in the case of Vanagas, we can perhaps apply war crimes in certain perspective, but for Vasiliauskas, I would see a problem here. Okay, thanks.
Thank you very much, and I don't see any more questions, but I have one very general that stays with me from the very first moment when Dovilė sent me an email asking me to join the conference. Why Lithuania? Why Drėlingas case happened for Lithuania? It's not the only state that was under the Soviet regime after the Second World War, not only Baltic state, not only country where, well, region of former Soviet Union where such atrocities were happening, and also Poland, not being a Soviet republic, also faced the same problems. Why Lithuania was so eager and persistent with trying to prosecute those responsible for post-Soviet crimes or Soviet crimes, post-war crimes, and why not any other country? Is there an explanation to it? Because it is striking that it's not, as we already learned, it's not only Drėlingas case, but also other cases that led the way, including the European Court of Human Rights cases, and also the activity of Constitutional Court, Supreme Court that were mentioned in Drėlingas.
If I may, my just very short thought would be, okay, why Lemkin developed the Genocide Convention? So he was the one guy who had an intention to put this crime into international law. So I think it was a little bit about Lithuania as well, or Latvia in Kononov case. For example, it just happened so that Kononov case happened in Latvia, and it played very important role to show that let's say war crimes could be committed also by the other party to the conflict. Then I think Lithuania, at least from the Baltic state, our resistance was the biggest one, actually. And again, perhaps Monica would tell what was the reason why we saw, let's say, resistance. So, I guess that every country has its own unique perspective. And for example, when we're talking about the Eastern Germany, then Berlin Wall cases when people tried to escape. And so I think it's perhaps coincidence based on historical parallels. So, but maybe I'm wrong, I don't know. So who would like to add?
Please allow me to slightly disagree with you. Not Lithuania, I think all three Baltic countries as one unit on different aspects of assessment of Soviet crimes. So of course, genocide is just because both practical reasons, what has been mentioned that in Lithuanian criminal law in certain time there was no other crime, only the genocide defined, but we can see, and Justinas mentioned the Kononov case, that was also very important, and not only Kononov, against Estonia, I don't remember all of them, but Kolken, Kisly, and Pennard, something like that. We got the main conclusion that actually the Soviet, and of course, currently the Russian regime is strongly against that, even on the constitutional level provided certain ideology, but on the level of European Court of Human Rights, we, from all these cases, we have the main message that both regimes can be assessed and tried under Nuremberg law. It doesn't matter who reached the victory, but it's the same rules, they all should be applied equally, as we can't have different notions of humanity.
So, dear participants of the conference, dear audience, online audience, please welcome our last, but of course not least, speaker, also from United States, Professor Mark Drumble. He is a professor at Washington and Lee University School of Law in the United States, and he will be presenting the report, which is called Fragmentation and Judging in International Law, Genocide as Before Different Courts. So, welcome, Professor, and the floor is yours. Take your time.
Hello, and good afternoon or good morning, whenever you'll be listening to this. Good day to all of you. My name is Mark Drumble. I'm a law professor at Washington and Lee University in the United States. And I am delighted to participate in this very, very important event discussing key aspects of accountability, law, and justice for Lithuania. I know I'm the last speaker of the conference. And I think as the last speaker, what I would hope to do is not only look back on some of the themes that have been covered so far, but also look ahead. And what do I mean by this? I mean the following. I think a lot of our time together in the conference has focused on the historicity, the legal aspects, and also the political aspects of the European Court judgment, recognizing genocide in Lithuania. And I think what I would like to do in my remarks is focus on the broader effects of the Drėlingas case on public international law more generally, looking outwards on the effects of this judgment on the international legal landscape, as opposed to just the Lithuanian landscape, so as to end perhaps on a slightly different note. So the title of my remarks is Fragmentation and Judging in International Law, Genocide as Before Different Courts. And what I would like to do in this frame is to place the work of the European Court within the broader tapestry of public international law, and also to ask a question or two about the role of the judge when interpreting international law. Let me make 4 points in the limited time that I have. First, the European Court now joins an array of other international courts in defining a historical tragedy as genocide. The International Criminal Tribunal for Rwanda, the Yugoslav Tribunal in Cambodia, the International Court of Justice, and a variety of other international institutions have taken the term genocide and applied it to a particular context. Along the way, whether that path is criminal or civil, in terms of remedy, we have seen emerge slightly different definitions in slightly different places by slightly different courts, rooted in different facts. And this can be constructed as the process of fragmentation. In other words, a universal legal concept becomes moved or shifted into a variety of more particular and more flexible places. My second point relates to the reality that even in the Drėlingas case itself, judges approached things differently. In other words, there was a majority and a minority. Courts don't speak with just one voice. Conversations about genocide or no genocide happen through people, and judges in the end are people. So what does that mean? That we have an individuality and an idiosyncratic reality that different judges may see the same term and the same facts differently. Thirdly, we have a different form of fragmentation, and that's within the court itself, where now we have a case from Lithuania that we're discussing that achieves a result that's different than a result achieved in a case not so far before, where genocide was not found. And here we have a sense of fragmentation within courts, where different realities lead to different outcomes on the same fundamental question. And my fourth point is the final, and that's the big normative takeaway. Lawyers are generally prone to see themselves as logical, Cartesian, organized, predictable, dare I say almost scientific. But fragmentation is messy and confusing and ambiguous and unpredictable and unsettling. And yet, in this instance, the arc of justice roots itself in fragmentation and diversity, a little messiness and differences. And to me, this gives rise to the final question that I would like to ask as we wrap up, and that is, should law always be cerebral and logical, or should law also be lived in life? Lived in the reality of a certain level of unpredictability, of change, of movement, and of dynamism. And at the end of the day, I think this is a very interesting question for public international law that is reflected in and by the reality that many different courts in many places adjudge the one universal crime of genocide with one universal definition and approach it differently. And perhaps at the end of the day, that fragmentation is to be welcomed and not necessarily feared. Thank you very much, and have a lovely remainder of your day.
Thank you very much. And I guess this is really the end of the conference. I'm not sure whether we should finish right now. Thank you very much. Thank you.
Dear conference participants, now our conference has come to an end. I believe we had a very fruitful discussions in all three panels, and of course there were raised, many questions were raised, even more questions were left unanswered. But what is true to tell about Drėlingas case after this event, that Drėlingas case and some argumentation given in that case is giving more challenges for the future to be solved, and I am more than happy that our conference at Mykolas Romeris University was held with such distinguished speakers, not only from Lithuania, but also from Poland, United Kingdom, United States, Italy, then of course Estonia, Germany, and Latvia. So all these participants of the conference contributed greatly to the future perspectives of the Drėlingas case. So thank you very much for your attention, and I hope we'll see you soon in our upcoming events.